Okay. Continuing. All right. I'm going to share that screen. And then what I'm going to do is presentation. There we go. Okay. Everybody see this? Well, my name is Jody Millman, and it's really nice to be here with you at the Ferguson Library tonight. As Ben said, I'm an attorney and I'm a writer, and I'm glad that I'm able to create or have a distinct and unique perspective, because I find that in talking to my colleagues and talking to my friends who are writers, a lot of them don't really understand what their rights are when it comes to protecting their artistic rights in their books. So we have a lot of material to go through. As I said, we will go ahead and I'll answer questions at the end of our session. This is what we're going to cover tonight. We're going to talk about intellectual property. We're going to talk about copyright registration, case, which is the new a new procedure we'll be discussing, fair use, public domain, business entities, and publishing contracts. Now, what is intellectual property? Intellectual property is kind of it's a catch-all phrase for works that are created by musicians and writers and artists and inventors that entitle them to protect and file to the government for protection in their tangible expressions of creativity. They come in three different varieties, three different colors. We've got copyrights, we've got patents, and trademarks. And we're going to discuss what is the difference and what does each protect. First, we're going to start with copyright. Now, everybody is used to seeing this little C with a circle. That's called our friend the copyright bug. And the copyright protection is protected by Title 17 of the United States Code. What does copyright protect? It protects literary works, film, musical works, sound recordings, broadcasts, paintings, and blogs. Also, if you're an artist, it protects visual arts, it protects photographs, and we're going to talk about a few things as we go through this that it does not protect. Now, who is a copyright owner and what does copyright protect? Well, first of all, from the moment that you create a piece of work, whether it's a manuscript or a poem or a blog, you are considered the author, except if you're a work for hire. And what a work for hire is, if you work for a magazine, let's say, for example, and they're paying you, you're on their payroll to do the work for them. In that event, you're a work for hire and your company becomes the copyright owner. Now, one thing I have to stress is merely that coming up with an idea doesn't make you an author, because that is something, an idea is not copyrightable. And I also want to mention that you'll see these slides that I'm working with. Several years ago, I took a class in copywriting comic books and graphic art, graphic novels. And these are some slides that I had borrowed from the New York State Bar Association, because they really drive home and they're very clear and they're very clean. And they really help me express to you and describe what a copyright is and what intellectual property is. Here, for example, you see we have a copyright column. And when you have a copyright in a book, or let's say a manuscript, what is included in that? Well, first of all, you can copy it. You can make, you can print it off and distribute it and do whatever you'd like with it, which is basically publishing it. You can distribute it. You can perform it if it's a play, or if it's a reading, you have the right to stand up in front of a group and read your creative work. If you're an artist, for example, you can publicly display your work. You can hang it on the wall in a gallery. Or, for example, if you're a poet, you want to publish your work or publicly display it on the internet, copyrights give you the right to do that. Also, another really important segment of this is called derivative works. And we're going to talk a little bit more about that in a moment. So as you can see, copyrights really is a basket of rights. The right to copy, distribute, publicly display, publicly perform, and derivative works. Now, what is a derivative work? A derivative work is when you have an original work and it's all of the things that grow out of that particular item. For example, we have our copyright golem. You could create a comic book out of him, a TV, a movie, a video game, a toy, anything that is based on the original work and flows from that original work is known as a derivative right. Now, you cannot copyright an idea. And let's take a bit of a look at this through the eyes of Shakespeare and Romeo and Juliet. We all know that the trope that's included in Romeo and Juliet is two star-crossed lovers, right? Now, over the years, that idea and that basic concept has been spun into hundreds of different books and plays. Look at West Side Story, Twilight, Outlander. There's so many, Titanic. There's so many different ways that idea, that underlying idea of star-crossed lovers has been expressed. However, each one of those people, let's say Leonard Bernstein or Stephanie Meyer or Diana Gabaldon, is entitled to protect their specific expression of that trope. See if I take a drink of water. So what that means, if they take that idea and create a book such as Outlander or Twilight, they're entitled to that expression of that story. So again, you can copyright your unique expression of this star-crossed lovers. Now, one of the things that we can't copyright is our recipes. And I came across, there was a really interesting article recently in the New York Times about copywriting cookbooks. And the Copyright Office views a recipe as a mere list of ingredients. They do not view it as any kind of creative expression. The way that a lot of cookbook people get around this and authors get around this is they write personal essays and they have beautiful photographs or they have all kinds of descriptions of those ingredients. So that in itself is entitled to copyright protection, not the recipe itself. And this also has become a big grounds of dissension between chefs, because they basically steal each other's recipe. Take, for example, a chicken cacciatore. I made that for dinner last night. I went on Food Network. There had to be at least 10 different recipes of chicken cacciatore, and none of them were able to be copywritten because they're a list of ingredients. However, if I went to Reed Drummond's book and the way that she described it in the photographs, that's something that will be entitled to copyright protection. Something else that is not subject to copyright protection is your website. And I get this question all the time. Websites are not able to be copywritten under the copyright law. However, any artwork, photographs, videos, music, or other content that are included are individually copyrightable. Now, some of the key things I want to tell you about copyrights is, first of all, it's very easy to create. From the moment you put your pen on the paper or your fingers on the keyboard, your work has been created. It lasts for the life of the author plus 70 years. And technically, no registration is required. However, I strongly recommend registration, and we're going to talk about that in a moment. The place to register it is written here below, www.copyright.gov. Now, why do we want to register it? We want to register it because, first of all, it puts the public on notice that we know we are the owner of the copyright and of this particular work. It is legal evidence of ownership. When you get that little certificate, it is something you can frame and it shows that you are the owner of your particular work. Also, having the certificate itself, it's called prima facie validity of your right. Okay, so it's immediately valid. It shows you have a valid copyright. Also, it allows you to bring an infringement action, and it allows you to get court costs, attorney's fees, certain things that you are not able to get and pursue in the event you have not registered your copyright. And it's also a maximization of damages that you can receive for infringement, which is when someone steals one of your work. Also, it entitles you to use what's known as the new case procedure. The case procedure was something that was snuck in to the COVID relief bill back in December of 2020. And what it did was it set up a really nice and very inexpensive streamlined process for people like myself and yourself to protect our copyrights in the event of an infringement. Before the case procedure existed, we would have to spend $500 on fees. You have to get an attorney. You have to go to federal court in order to protect your rights. What the case procedure does is it sets up a tribunal, and it allows you to represent yourself. It's streamlined. They're going to be turning cases over very quickly. And it really allows people who don't have a lot of money, that are not J.K. Rowling, to be able to protect the rights in their work. So one thing I also want to note is that in December 2020 is when the law went into effect. That's the small claims procedure. Now, they're in the process, they've just appointed the tribunal, they're in the process of getting the procedures. So I expect by the end of this year, you would be able to bring an action before them. And the place to find any information about that, again, is www.copyright.gov. So if you want to go register your copyright, what's it going to cost you? Well, first of all, as I said, you're going to go to www.copyright.gov. It's going to be $45 for a single registration. So for example, when I send in my novels, it's $45. However, let's say that you're a blogger, or let's say that you're a poet, or you write short stories. If you have a group of, let's say, not more than 60 works that range from 50 words to 17,500 words, and they've been published, on the internet or however, within a 3-month period, you are able to file a group registration for all of those works in a lump sum. So that means that you don't have to spend, let's say, $45 per poem. They allow you to now group them together. And again, you would go to copyright.gov to go ahead and do your group filing. Now, I don't want you to get nervous if you don't get your certificate within a short period of time. It takes about 12 months. They are severely backlogged, with COVID, and even before that, it took 12 months to get certificates. But what I always recommend is that you go ahead and you file online, because when you file online, you're able to print out your receipt, and that shows that you've gone ahead and you've filed your certificate. You can do it through snail mail if you don't have access to a computer, but all of you are on Zoom with me, so I'm assuming you have access to a computer, so go ahead and file your copyrights online. Now, this is the proper template for your copyrights. And if you're a poet, if you're a writer of any type, I want you to put a C with a circle, the year and your name on the cover sheet of your manuscript. That alerts the world that you know that your rights are protected. So there's the proper template for you. C, circle, 2022 Jody Susan Millman. That's me. Now we're going to switch gears for a second. We're going to talk about trademarks. Now, where a copyright is a protection for a work of expression, a trademark is a protection which is provided by the Lanham Act through the U.S. Patent and Trademark Office for a logo that represents a good that's in commerce. So if you look at the little screen here, you see the R with a circle. Whenever you see that, it means it's a registered registered trademark. And also, if you look at some of the examples, we have McDonald's, we have Canon, we have IBM, we have Oreo, we have Quaker Oats. Those are all trademarks that we know. They particularly identify a product that is in commerce, and that is something that is protected. Now, separate from that is something called a service mark, and that is similar to a trademark, except it protects a service that's in commerce. So for example, I belong to the Romance Writers of America. This is an organization that's entitled to has a registered trademark and also a service mark, because they provide educational services, they provide grants, they have conferences. It's really an education-based organization, and they're providing a service, so they would be entitled to a registered service mark. Now, here we kind of have an armoire that shows us what trademarks protect. Well, they can protect characters. Okay, so for example, Harry Potter can be a trademarked a trademarked character. If it represents a line of goods like underoo, underwear, or Harry Potter, uh, not batons, magic, magic wands. The title of a series can be trademarked, not an individual name of a novel. So let's look at the Outlander series. Outlander series can be trademarked. However, Diana's first book, Outlander, cannot. Also, distinctive logos, we talked about that. Quaker Oats, IBM, Subaru, you name it. Our world is surrounded by trademarks, and trademarks surround us. And also distinctive costumes. So for example, Beauty and the Beast costume could be trademarked. Or if someone's going to Comic-Con and they've designed a special costume, that also could be something that's subject to trademark. Now, what is the difference between a patent? A patent is also granted by the US Patent and Trademark Office. It represents and protects inventions, okay? And it's also, as I said, US Patent and Trademark Office. It's more scientific in nature, as opposed to being commercial in nature or artistic in nature. Oops, sorry. I also want to talk about there are 3 different kinds of patents. We have a manufacturing patent, which is a process. A process can be patented. We also have, and it's a design patent. And I always like to talk about this. I always hold this up. You see, this is a butter hub. It's someone who took an original design, which was a butter dish, and made it better, made something unique beyond the original invention. And I don't know if you could see it, but this says it's got a patent pending. And what they did was they put little feet on it, and they put a magnet on the top to hold a knife. What they did was they enhanced and improved an existing design. So they are entitled to a patent. The third type of patent is a patent that's given to a plant. So let's say that someone grafts plants together, an asexual, it has to be an asexual plant, and a new plant is created, a new type of rose, a new type of tulip. That is entitled to a patent. Next, we're going to swing back into the public domain. And the public domain means that it's a piece of artistic work. It can be a film, a book, a poem, a piece of art, a piece of music that is now had all of the copyrights are swept away by time. And this year, every January 1st is called Public Domain Day. And that's when a new group of books, for example, enters the public domain. This year, anything created before 1925 has entered the public domain. And here are some literary classics we know of that entered the public domain a couple of weeks ago. We have Ernest Hemingway, The Sun Also Rises, T.E. Lawrence, the 7 Pillars of Wisdom, upon which the movie Lawrence in Arabia was based. We have Kahlil Gibran, Edna Ferber's Showboat. We also had Felix Salten's Bambi. And the really big loser this year is at the top of the list. That's Winnie the Pooh, created by A.A. Milne, and the illustrations are by E.H. Shepard. Now, this particular public domain work is something that is unique, but I think is going to be an engine of the changes of the law, or we're going to see things that happened that are going to be happening, because Winnie the Pooh is the 3rd most valuable, top grossing franchise in media in 2021. Behind Pokemon, which grossed 100 billion, Hello Kitty grossed 84 billion, grossed $80 billion and is tied with Mickey Mouse. So as you can see, for the Walt Disney Company, Pooh is an extremely valuable financial juggernaut. So now, because the book has gone into the public domain, that means that the original story created by A.A. Milne is now available for anybody to copy, literally copy, make digital copies and distribute it, incorporate the characters into your own stories. It just is really a floodgate of Pooh that's been opened and allows you to express your creative juices and see what you can do with Winnie the Pooh. Now, in the original book that's just gone into the public domain, the characters of Pooh, Piglet, Eeyore, Owl, Rabbit, Kangaroo, and Christopher Robin all entered the public domain. Now, we have a unique situation because of Disney. Disney owns the trademarks and copyrights to Pooh, but the law provides that it's only entitled to protection for new material. The Supreme Court has also held that you can't hide behind trademarks in order to extend a copyright. So Disney's rights probably are going to be very limited in the future. So for example, if you see I know they have a Winnie the Pooh line of clothing. As long as that is a trademarked good, like we saw with Quaker Oats, Disney will continue to have rights in it. But if you want to go ahead and make a Pooh t-shirt, make a Pooh book, make a Pooh movie, make a Pooh play, you're entitled to do it. But this is a really good example of when there's a conflict in the law between copyrights, derivative rights, and trademarks. And the reason why I said it's going to be a floodgate is because in 2 years, in 2024, Mickey Mouse is going to enter the public domain in the form of Steamboat Willie. That's when that cartoon came out. And it'll be interesting to see what Disney is going to do to protect its most valuable property. And one of the things public domain does, and this is another example, it gives us free quotables. So for example, from The Great Gatsby, which went into the public domain in 2021, you can now make a t-shirt that says it's better to burn out than fade away. And Woody Guthrie's Blown in the Wind entered the public domain in 2020. So now you can print a t-shirt that says, how many years must people exist before they're allowed to be free? So another example of copyright, well, public domain is when you can use a product or use a material because the copyright has expired. The question is, can you use material when the copyright has not expired? And the answer is found in fair use. And fair use means that you're using someone else's material for educational, nonprofit purposes, such as criticism and commentary. In those cases, you're allowed to go ahead and use someone else's material, except there are 4 provisos. And these are the things that the courts will look at should there ever become a conflict between fair use and a copyright owner. Was the purpose used for educational purposes, such as criticism or parody? What is the nature of the copyright? Is it factual or creative? Courts are usually more willing to allow a factual work to be used as opposed to creative work. And it can only be a teensy-weensy portion of that work. You can't go ahead and plagiarize the whole thing. And it can have must have little or no impact on the marketability of that underlying work. And let's take a look at a few examples. But before we do, so for example, fair use can be claimed for criticism, such as a newspaper, and parody. See, here we have Poor Charlie Brown, criticism and parody. And here we have a couple of fair use examples. There's an example of a group called Girl Talk, and she was a DJ. And what they did was they mashed up a bunch of songs and they made their own song from the originals. And they used such a little bit that you really couldn't see who it was. It was just a mashup. That was considered fair use. Fair use was also, there was a guy who took YouTube videos of himself playing video games, which are protected by copyright law, but it was kind of a crazy thing. He'd do crazy stunts while he was going ahead and playing his video games, and that was considered to be fair use. Also, if you think about somebody like Ken Burns, who makes documentaries, What he does is he takes archival material, photographs and music and interviews, and he puts them together into a documentary. That is fair use, using archival footage to create a brand new work. And then there's the case of Shepard Fairey. And some of you may not know the name, but when I show you the next slide, you'll recognize the image, who's a graphic artist. And what he does is he takes magazine pictures and then makes art out of them and posters and makes a lot of money. And one of his most famous is, recognize these images? This is an example of Shepard Fairey's work, the Obama Hope poster. And this ended up as being a huge lawsuit with 3 parties involved. And it was a question of copyright versus fair use versus work for hire. Now, originally, if you look at the photograph of Obama, that was taken by the Associated Press when he was running for president, and it was a widely used image. What Fairey did was he took it and made it into a piece of art. And then what happened was the Associated Press sued Fairey and said, look, you took our image, we're suing you, it's an infringement, there is no fair use, which is what Fairey said. Hey, it was a public image, it was widespread, it was fair use. Then the third party was a guy named Garcia, who was the actual photographer who took the image. He claimed that the image belonged to him. Well, he was immediately thrown out of the lawsuit because he was what's known as a work for hire, as I told you before, that when you get paid by your employer to create a work, it's not your work, it's the work of the employers. So the gripe was really between the Associated Press and Fairey. And finally, Fairey backed down and he said, okay, I recognize that I did take the work, and the two of them entered into, or the AP and Fairey entered into an agreement, a licensing agreement, where the image was licensed from Fairey and they would split all of the money going forward. Now let's talk a little bit about defamation. Defamation is when you say bad things about somebody that are not true, and you get sued for it. There are 2 different types of defamation. The first type is libel. Libel is a tangible form. When something is printed in a magazine or a newspaper, and right now there's a big case that's pending between Sarah Palin and the New York Times. The New York Times, it was an opinion in an op-ed, made certain alleged claims about Sarah Palin, which they then admitted were untrue. They apologized to her, but she said, the heck with you, I'm going to sue you anyway. So this is a case that I think you're going to see in the news a lot going forward. Slander begins with an S, and that's when you say something about someone that is untrue with malice, a forethought, and it is speech. It's when you speak it, like a TV broadcast or a podcast, a news broadcast. So we have libel is in writing, slander is spoken. And this is a great little cartoon that I like, Sue the author, and everybody's standing in line. Now, why is this concept important to writers? I'll tell you why. Because if we're going ahead and we're writing a book and we're including real people, let's say we're writing about the billionaire space race and we're talking about Jeff Bezos and we're talking about Sir Richard Branson, and we should have Elon Musk in here, but I guess he's not in this picture. But we're talking about them. When you describe characters that are like these 2 real life people, you cannot hold them up to ridicule. In other words, if you know a secret about them, you cannot reveal that secret in print. You can only talk about things that are of public knowledge. You cannot hold them up to ridicule. Otherwise, you could get sued for libel. Now, one thing about public officials and people who are in the public is that they're held to a higher degree of a higher standard of proving that you've libeled them because they're out in the public all the time. Under the United States v. Sullivan, which is a landmark case, It held that public officials have to show malice. It means that you have to have said these things intentionally to harm them, that you knew that they were false and you went ahead and you said them anyway. So I always tell people that if you're going to write about a realistic person, let's take Paula McLean's book, The Paris Wife, where she talks about Hedley and Ernest Hemingway. There's a gray area in those books. You really don't know what is true and what isn't true. She made it shadowy so that you're getting some of the characteristics of the true people, but she's made them bigger than life, that they're larger than life. And that's what I tell people to do. There are also attorneys who will, if you send them your manuscripts, they won't edit it, but they will read it through to make sure that you have not violated the libel and slander laws. I mean, that's really going to the nth degree, which isn't necessary. So just go ahead and remember to go big or go home when it comes to using a real life person in your stories. So we're going to quickly talk about creating a business. Now, let's talk about the different types of businesses. As you can see, I have an LLC right here. You can be an individual, you can be an LLC, a corporation, or a partnership. Individuals are usually, let's say Jody Millman. And if I wanted to use my pen name, for example, Jody Millman, writing as Susie Smith, I could file what's known as a certificate of doing business with my county clerk, pay the fee of $50. I get a little certificate saying that I have used an assumed name. An LLC requires that you file papers with your Department of State. You register your LLC, your limited liability company, with the state. When you register with the state, as with a corporation and an LLC are umbrellas. So what that does is protect you from personal liability in the event you're sued, whether it's for anything or for libel. You have a shield over you. A partnership is when you join with someone else. Let's say that you're a children's book writer and you're writing a book and you've got a friend who's your illustrator. What you would do is you form a partnership agreement outlining what your duties and responsibilities are to each other during the term of your partnership and what would happen in the event that your partnership severs. It's always good. I always tell people, if you're co-writers for whatever reason, enter into a little partnership agreement so you both know where you stand with each other. So why do you form a company? You form a company to limit your liability. It's to protect your assets, like I said, with an LLC. And note that all contracts you sign, if you're operating as a company, must be signed in the company name. So for example, the publishing company that I've signed with is in the name of my LLC, J.S. Millman LLC. And again, as I said to you, LLCs, as well as corporations, must be filed with the state. And really, you should check with your attorney or your accountant to see if any of these make sense for you. Now, let's talk about the publishing contract. And this is something I know that everybody wants to know about it. Well, what is a publishing contract? It's an agreement that you enter into with your publishing company. So both of you know what your rights are, and it specifies the specific terms and agreements regarding the publication of your work. It clarifies the terms of the agreements between the author and the publishing company, and also provides ramifications in the event of a breach. We're going to look at a few key provisions. Okay, first of all, it's going to outline what work is included. Are you signing for one book? Are you signing for a series of books? Are they going to have an option on any future books you have which contain the same characters? Your contract has to describe the work to be published. And also the rights. What kind of rights are you giving them? Are you giving them world rights? Are you giving them US rights? Are you giving them rights to book clubs, audio rights, video rights? Exactly what rights are you giving away? And is it exclusive? So for example, if you have a contract that provides for you to retain the audiobook rights, does that mean that you can go ahead and go to another company to go ahead and have your book recorded by an audio narrator. Now, it also provides the manuscript delivery. What is the specific date that the author is required to turn the manuscript in? That's a drop dead date. Also, it should contain a publication schedule, so you know what your obligations are. First, you turn your manuscript in, then you go through the editing process, the redlining process. So all these procedures you go through, and all of those dates are important dates and should be included in your contract. And also, what is the delivery of a manuscript? Suppose you give them something which is, frankly, a piece of dreck. Do they have the right to reject your contract because you haven't properly delivered your manuscript? And who is going to be the copyright owner of your book? Danger Will Robinson. Danger Will Robinson. Always be the owner of the copyright. You don't want to have to go to them in order to get your copyrights back when your agreement, ends. And another thing that's going to be included is the term of your agreement. Is this something that's going to be a 3-year contract, a 4-year contract? How long are you tied to this company before you could move on? And also suppose that you want to go ahead and write a book of children's book stories while you're publishing crime novels. Is it exclusive? Do all those books have to go through your publishing company? These are all things that are going to be set forth in this agreement. More key provisions are the publication details. These are more obligations on the part of the publisher. The previous slide talked about the obligations of the author. These are the obligations of the publisher. How and when will the book be published? So for example, is it going to be just an ebook? Is it a trade book? Is it a hardback? Is it just paperback? How is it going to be published? Is it just going to be an ebook? Okay, and when is that going to take place? Is it going to be 12 months from the date you first submit your manuscript? Is it 12 months from the date of the final review edited version? Make sure all of that is included. Also, it's going to include a royalty schedule. And I want to talk a little bit about royalties. We'll jump back to these other things. But people always ask me, how much does an author receive when they sign a contract? Well, first of all, some authors get what's known as an advance. And what that means is that's a chunk of money you're given up front that you have to sell enough books to earn it back before you see another penny of royalties on your book. So let's look at this writing for less. For example, if you have a hardcover book, it sells for $28, the publisher gets $14. That's the yellow portion out of the sale of this book. $4.20 goes to the author. It's usually a 15% royalty, which would be $4.20 per book. So where does the other blue part, where does the rest of that money go? Well, it goes to the distributor, it goes to the manufacturer for the production costs. So you see, out of the whole, actually it's the producers of the book and the distributors who make the most money, as opposed to the author who makes only 15% of the cover price. So let's look at, for example, an ebook. An ebook, authors earn percentage-wise a bit more, because if an ebook sells for $12.99, you see there are so many fewer production costs. What is it? You create a PDF, you upload it into Amazon, boom, very little. Maybe there's a cost for the cover. Okay, so there, the publisher is getting a big chunk of change. And again, the author is getting percentage-wise really more than they earn on the hardcover book. So in our example here, let's say that the publisher says, I'm going to publish 5,000 books, and you're supposed to get a royalty of $4.20 per book. That means you have potential earning on that $5,000 of $21,000. If they've given you a $10,000 advance, you have to earn that out. You have to sell enough copies on that in order to see another penny, in order to start to earn that potential $11,000. So again, the publisher's profit is small compared to the distributor. And you see, I've got another bar chart that shows you what we poor authors make. Now, some more key provisions that I want to talk about are advertising and promotion. Are they going to promote your book? And I'm going to tell you from vast experience, 90% of the promotion is going to be on the shoulders of the author. And that's just the way that it is. I mean, they will work with you. You'll be part of their team. It depends upon the company how much they'll invest in you, but you have to remember that if you go with a major firm, let's say like Houghton Mifflin or Simon and Schuster, you're one of a few group of us. You're one of a big group of authors. And so how much time are they really going to be dedicating toward your book? Very little. Most people end up using independent PR people to help them with their launches. But 90% of it's going to be you. You're going to be the one who's going to contact the libraries, write the press releases, try to get coverage in the newspapers, set up your events. It's a lot of fun, it's a lot of work, but most of the time it's going to be on you. However, if your publisher is agreeing to do something, make sure that it's included in your contract. Another thing that's important is the termination. How can both of you walk away from this deal? Well, for example, if your publisher doesn't publish in time, if they keep putting it off, if, for example, you don't deliver your manuscript as required, that termination agreement will be set forth in your in the contract, and then will allow you to take your carpet bag and go somewhere else. Some other additional terms: the right to revise your manuscript. You want to make sure that the words that are coming out on the printed page are your words. You want to be able to revise it. You want to approve or have some kind of meaningful right to contribute or have comments about the cover, the title, and the interior design of the book. You want to be able to audit the royalty statements to make sure you're being paid what you were told, what you were promised you were going to be paid under contract. Again, you want control over editorial changes. You don't want to have a book about Sue and have this, when the book comes out, it's about Betty. You want to make sure that you're in charge or have some kind of control over editorial changes. And also, what is the definition of out of print? Because out of print is usually a key term in terminating the agreement. And what that means is that that your work is no longer available. But we all know that ebooks live forever. So is your book ever out of print? Well, what you try to do is limit it by saying that 25 books haven't been sold within the last quarter or half year. Then it's determined to be out of print, and you're able to get out of your contract and walk away. And also net receipts. If your publisher is claiming expenses against what it owes you, be sure you know what's being charged against you, so that you get what you're entitled to as far as your royalties are concerned. You don't want any surprises. So, do's and don'ts. Know your goal as an author. When you go into a publishing agreement, what are your long-term goals? What are your short-term goals? And what's that relationship going to be with your publishing company? Read the entire agreement. Remember, agreements are written to baffle you. They're written by the publishing company on behalf of the publishing company. So read them, and if you don't understand them, there are a couple of things you could do. You could get an attorney to help you read it. You could contact the Volunteer Lawyers for the Arts, which is a free organization. And I'll give you the website, how to get in touch with them in a minute. They'll be able to help you review the contract. Same thing if you're a member of the Authors Guild. They will review the contract for you for free. And if you want to see a sample agreement, you can go to the Authors Guild website, and they posted it there. So you can get an idea. If you have a contract, you can compare it and kind of figure out for yourself whether or not it's a just and equitable deal for you. And ensure the agreement is accurate. Remember, if they tell you something and it's not in writing and it's not in that agreement, it's not going to hold any water for you or in court. Everything must be agreed upon. It's got to be in writing. And again, revise and negotiate. Don't be afraid that they're going to pull their deal, they're going to pull their offer back just because you want to change the terms. They know and they expect you to change the terms. And if you're going with a good company, they're willing to work with you. It's really important to have good communication with your company. And again, once you have your publishing deal, put it in a safe place. Don't. This is kind of the flip side of the do's. Never sign an agreement without reviewing it. Get everything in writing. Never assume any terms are agreed upon unless they're in the agreement. And as I said before, do contact a lawyer or have your agent review your deal. So here are some resources for you. We've got www.copyright.gov. If you're more interested in learning some more about fair use, we've got this Stanford EDU. They've got a great program on fair use. And Duke University has one on the public domain. That's the web.law.edu. Authors Guild, I'm a big fan. They've helped me a lot. They also will design a website for you for free. So, I mean, it's if you're a member. So it's a really great organization. They have webinars, seminars, they've got everything. Check them out. If you're looking for free legal advice, there's the Volunteer Lawyers for the Arts. This is New York. And also, most of what I've written in here and with all the slides, I've written longer dissertations on them in my blog. So if you go to my website, which is jodymellman.com, and you go to the Writers Law School, if you're interested in reading a little bit more, getting into the teeth of things, you can find it there. So if you'd like a handout that I prepared for this presentation, you can email me at jodysusanmillman@gmail.com, and I'll be glad to email it to you, okay? Or if you don't remember that, you can go to my website, and I've also got a contact me, so you can contact me through my website. You can find me on Goodreads, you can find me on Instagram, and also on Facebook. And since I'm a lawyer, I have to add a disclaimer that all the information I provided today is basically for educational purposes. It's not intended to be legal advice, and it's just for general information purposes. Well, I hope you've enjoyed this presentation. I'm going to escape now from screen share, and we'll go back to questions. You still there with me, guys?
Yes. Hi, Jody. What a great presentation that was.
Okay, how can I stop screen share? Oh, I am going to quit the screen share.
Great.
There we go.
Okay. So, yeah, I guess I do have a question from chat.
Okay.
I don't know. So this is from Bruno, and he has so he's interested in putting on a photography exhibition, and he would like to show a photograph of himself and one other person that he asked permission from to use this photograph for. But the photo was taken by, I guess, the official photographer of the House of Lords in the United Kingdom. So would he have the rights to show that picture of himself in an exhibition? Or does he need to request the rights from the House of Lords in some way?
Well, I'll answer this very broadly. Anytime you're displaying the works of someone else, you have to get their permission because it's not his photograph. You know, if it was a photograph, if it was a selfie that anyone has taken of themselves, they're entitled to use it. But if someone else has taken that photograph, they have to get permission from that photographer.
Okay. And he also had another question. This one, I think, has a pretty straightforward answer. So if pre-1925 material is in the public domain, why then would the estate of Robert Frost cause so many problems for musicians who want to use lines from The Road Not Taken, which was published in 1915?
Right. Well, if it was published in 1915, we know it's in the public domain.
Well, isn't it after the author's death that public domain takes effect?
Well, what year was it published? It was published it's the life of the author plus 70 years.
Right. And
however,
go ahead.
okay. the copyright law changed in 1978. So there are certain rules that apply to works before 1978 and works that are created after 1978. So this would fall in the earlier group. And as I understand it, I mean, my mind has got cobwebs when it comes to 78. In 78, you could keep applying for extensions. You are entitled to a certain number of extensions of copyright.
I see.
Under the new law from 1978 going forward, there are no extensions. So it's life of the author plus 70 years.
So this is for anything published after 1978. It's automatically the life of the author plus 70 years.
Anything before that is their extensions. And this is going to come into play because if we look at the world of music, like Bruce Springsteen and the Rolling Stones, a lot of those songs were published before 1978. So they're going to be treated differently than the newer work. And that's so it's going to be interesting to see what happens as those whether or not those extensions exist.
I see Bruno here in the chat has a follow-up to his question. If he makes the request to the House of Lords, but House of Lords doesn't respond, would he then be able to put on this exhibit of this photograph?
You have to get permission of the person that is the artist.
Right. And so even with a disclaimer that you tried and you didn't.
I'm not rendering legal advice. This is for general informational purposes only. Mm-hmm. Nice try, Bruno.
And Joan asks, with the example that we were just talking about, the permission from the photographer must come in writing.
Correct. Right. Generally, you get a release, from them.
Right, like a legal boilerplate release.
Yeah, and also it's wise. And this is kind of related to what I was talking about with the cookbooks. If you're borrowing someone else's work and you get their permission, put an attribution to that person. That's generally what I would do. For example, if it was a cookbook and a recipe and I borrowed it from Julia Child and I put it in another cookbook, I would attribute that to her. Similarly, if it was a photograph or it was a painting that I was using, I would definitely do an attribution. And one thing I always tell people too, and they always ask me about collages. When people do collages, I always tell them to stay away from registered trademarks, because it's just not a really great idea to do a collage, make posters out of it, make or anything, or calendars, and with someone else's work in it, someone else's registered trademark. That's really a no-no.
Okay. If there are any other questions, feel free to enter them in the chat, or feel free to hop on the microphone and ask directly.
And what I'm going to do in the chat is I'll put my email. So if anybody wants the handout, they can email me. Yes. There it is. They can email me and I'll be happy to send it along to them, because it's got those resources which are really kind of handy. So you see, we covered a lot tonight. I mean, this is just the tip of the iceberg, but at least people wouldn't, if you walk away with one thing, the one thing I'd like you to do is make sure that you copyright, you file a registration, you file for your certificate with copyright.gov. It's gonna prevent a lot of problems going down, going down the lane. And also it shows the world that that something belongs to you and that you're proud of the rights you have. And it's a nice certificate that you can put on your wall.
Okay, then.
Okay, I see Bruno has a question about fair use. Aside from the Obama case, a high profile one, it wasn't clear. Is artistic rendering permissive according to fair use? I don't really know what he means by artistic rendering, but let's say that, let's take Obama, for example. He took word for word, he took the image, the exact image, and then converted it into um, an artistic expression. The problem was he did not get permission from the underlying copyright owner to make that, he did not get a license, he did not get the right to use that photograph of Obama. So it was determined not to be a fair use. And again, did not meet the standard. It was not for parody. It was not for non-educational purposes, and it was not for criticism. It was for commercial purposes. So if you looked at those 4 criteria, it didn't meet any of those criteria. So it was not fair use.
Okay, then. Well, thank you very much, Jody. I definitely learned a lot, and I can see from the chat that I think everybody here learned quite a bit as well. So again, thank you very much,
Thank
and
you. I appreciate it.
yes, and thank you everyone for coming out to, or figuratively coming out to see
Right.
the presentation.
Stay warm and enjoy. Think spring, one day closer to spring.
Yes, every day is getting longer.
You got it. That's true.
All right.